All right, welcome everybody. Estate planning attorney Paul Rabelais here. Excited to present to you today. We've got colleague of mine, Christopher George. Let me get my thing straight here. Okay, so this is a much anticipated live stream that I'm presenting here because I've presented some live streams with some guest attorneys in other states, and I keep getting the question, Paul, when are you going to do one for California? So here we are. Lots to share. I've been talking to Chris for the last few minutes. We got a lot of stuff to go over. Larry's here. Larry, you are the one here that been asking you. Larry, by the way, Chris is our MVP #1 YouTube follower. He's on every live stream. I feel like Larry's part of the family, but I wouldn't know him if he walked in the room. But Larry, good to have you. So I'm going to jump in here. Chris and I were talking family tree, a lot of lawyers around. I'll give you my quick lawyer family tree. Then I'm going to turn it over to Chris to make an introduction and tell you how he got into estate planning. But yeah, my version is I was the first lawyer in my family, but don't ask me why. But my wife and I had 5 children. It all went by so fast, and as they started to go to college, they started asking me, what they should do once they finish college. I said, don't go to law school. It's tough. It's hard. Well, 5 out of 5 went to law school. 3 are already lawyers, and two are in law school right now. But no, I'm very proud of them. They're doing well. Of course, the question I often get is, Paul, are any of them going to join you in your practice? Remains to be seen. The older 3 seem to be carving their own way in the corporate law field and doing really, really well. We'll see what happens with the other 2. So, but excited to have Chris here today. I'm going to turn it over to Chris, and just always like to find out from other lawyers, how you got into estate planning. I know Chris wants to kind of share an important point about how we're not creating attorney-client relationships with anyone. So, Chris, why don't you fill us in and help us with an intro here?
Thanks, Paul. So yeah, to start off, just disclaimer, this is for educational purposes. If you want to reach out, we can discuss the design and go from there, but this is, just a very broad overview. And this presentation is not going to create any attorney-client relationship with me or my firm, Hills and George. So just want to put that out there. And then to answer questions about, how I got started in this. So I've always been into personal finance. And originally, I'm a business major. I thought I wanted to be a financial advisor, so I tried that out for a bit. But as Paul alluded to, I'm a third generation estate planning attorney. My grandpa, hung up his shingle here, the same building in Saratoga in 1972. And then his daughter, my mom, met my dad when they were studying for the bar. Then they took over, I'm going to say like late 90s, early 2000s. They're the succession plan. And then I started, in high school and in college, I clerk here. I needed some summer money and that sort of thing. And then worked at a few other estate planning firms during law school. And then, I've been an attorney here for about 3 years and change, and I love it. It's it's very humbling and very honorable to have people trust you with, their wishes, and it's just a very rewarding job. And yeah, I really enjoy what I do, and I plan to be practicing this for a very long time and continuing the legacy of the firm. So
Yeah, fantastic.
short and
All
sweet.
right, usually I don't hit the live chat until after we finish up, but with Larry, if Larry asks a question, Larry gets an answer. So Larry put into the chat, are there any problems using, and I'm gonna give you my take and then see if you have anything you'd want to add, Chris. Are there any problems using POD, TOD in California on bank and credit union checking accounts? So I know you're in California, Larry. We have a kind of a crazy system here in Louisiana where the POD rules, they don't actually transfer ownership like they do in other states. They just relieve the banks from liability for releasing an account to the POD beneficiary. So it's all confusing here in Louisiana. But while it is effective in other states, I'll give you an example. I was talking to and you don't have this problem, Larry, because I don't believe you have the California inheritance tax, but I was talking to a couple yesterday in the state of Washington, and Washington has a Washington estate tax, can be as high as I think it's 16%. And so they have an exemption of about $2.2 million. But if you don't use it, the Washington estate tax exemption is not portable like the federal estate tax exemption is. So it's a use it or lose it. And so couples in those states who need to use a state estate tax exemption maybe messing up by doing a TOD or POD designation to the spouse on everything because they may lose the first spouse to die's state estate tax exemption, but not an issue for you, Larry, not in California. At least that's my kind of perception. A lot of people using TOD and POD designations really as a probate avoidance tool. We'll get into California's probate here in a minute, but it seems to me like state legislatures around the country and lawmakers are enacting more and more legislation, enabling more and more assets, whether it's brokerage accounts or bank accounts or vehicles or or a home, or in some states you can title your LLC registration to transfer to a beneficiary upon your death. So more and more states are providing legislation and laws to enable more assets to pass to surviving loved ones out of probate. But Chris, what are your thoughts there on any problems using POD or TOD designations?
I haven't seen too many problems personally. One thing that has come up is, some people they'll do a POD and then, or TOD, and then the clerk at the bank will also title it as a trust asset. And when that happens, if it's over this year in California, anything over $184,500, you got to go to probate. So if it's over that amount, then that's for the probate court. So I have seen complications with that because a lot of bank clerks don't really they're not the most knowledgeable all the time. So things can be conflicted. But I mean, if you have like a simple estate, I don't see much of a problem doing that.
Yeah, I saw a blurb. I don't know if you know much about it, or I don't know if it's a big deal in California or not, but I seemed to read that there was a California bill proposed to increase the small estate affidavit threshold to 700 and something thousand dollars. Have you heard about that, or do you know anything about that proposed bill?
That would be a great idea. I think they
Yeah.
do need to raise it because the property values here they're just so high, not even just real estate, but there's a lot of high net worth people in California. We're the fifth, I believe we're about the fifth or sixth biggest economy in the world. So I think they gotta raise it a lot. I have not heard about that specifically, but I think it'd be great if they
Yeah.
did.
And Larry asked another question, similar question. Any problems with using POD, TOD on automobiles in California? He says, I have personal cars, truck, and a couple classic muscle cars. Like to see a picture of those that will go to children and grandchildren. So I know, one of my concerns depends on how old your grandchildren are, Larry. If they're minors, really tough leaving to a minor in their own name. If something's going to be left to a minor, it should be in trust. Maybe your grandchildren are adults. I'm guessing they are, Larry. But so yeah, apparently California, one of those states where you can designate a beneficiary on a vehicle. Again, legislature is creating more laws allowing things like that to pass out of probate. So any thoughts there on the vehicle aspect in California there, Chris?
The DMV, they have a very streamlined system for taking title off when someone passes. A lot of time it's joint owned with the spouses, but also our wills. So our trust, the revocable trusts for titled assets, like cash accounts, brokerage, real property, things like that. But the will, it's for tangible personal property. And a lot of times a car will fall into that. So, if there's no designation. In terms of the TOD or POD, I don't know if I've seen that exact terminology, but 9 times out of 10, it's a very, streamlined process. And if you want, Paul, I could send you the DMV form after this, where, if anyone's interested,
Yeah,
see what
I
it's like.
could throw it in the description, that's for sure.
Yeah. All right, I'll send that.
Okay, so I want to jump in kind of lawyer to lawyer, talk about I hear so many bad things and so many horror stories about the California probate system. And yes, I was doing a live stream yesterday with a lawyer in New Jersey. Actually, she's licensed in New Jersey and Florida. And yeah, the Florida probate really, really difficult, really, really expensive, takes a really, really long time. And then she tells me on the other hand, New Jersey's one of those where if it's relatively simple, there's some people kind of handling the probate themselves by filling out the forms. And so I don't think there's many states where, probate is really DIY, but I think there's a few where people can at least attempt it. But California, if you could, Chris, kind of walk through why California has just kind of such a poor probate reputation and whether it's deserved and what some of the issues and challenges are with probates in California.
Ooh, it's a loaded question. Probate here, it's a very dirty word. So we try to avoid it as much as possible because it's very antiquated, burdensome. Everything's public, and just a complex process, expensive. So California, first 100,000, there are statutory fees that the estate has to pay of 4%. The next 100,000, 3%. The next 800,000, 2%. The next 9 million, 1%. And it just kind of goes up from there. I mean, the fee, the percentage goes down, but statutory fees, and so it's anything over $184,500 collectively. It's not just like, oh, this institution is one under this and this is another one, so I can do a small state affidavit. The probate code, makes it clear it's collectively. And, why is it so slow, or why is it the way it is? It really hasn't changed a whole lot since this firm's been around. We've been around since 1972. I think, there's just a lot of court supervision compared to other states. And California, there's the Uniform Probate Code, a lot of states following, and I think it makes, it easier for the DIYers out there. It's not involved with the court system, but California, the legislature, for whatever reason, it's a lot of supervision of the courts, and it doesn't eliminate the roles of attorneys either. So, when you go to probate, you're going to get, what's going to happen is the heirs are going to try to get into an account. It's going to be frozen. And they're going to say something to the effect of, we need letters testamentary. And testamentary is just where you want something to go. As Paul's talked about in his videos before, you're your testator of your will. If you die without a will, you die intestate. There's intestacy succession, which is just, defined certain family members, defined, it goes to them in equal shares. But yeah, so what's going to happen is you're going to get that. And then we actually have in our trust. So we have our trust. We have the Exhibit A, which enumerates all of your assets. And if, for example, maybe there's a bank account you guys forgot about, just, there's no beneficiary designation. If you put it on your Exhibit A and you pass, that's enough intent for the court. It's called a Hagstad petition. It's been around since 1993. You're able to confirm the trust asset because you can show, in coordination with our trust, with our will for the residue of the living trust, you're able to show that this is what the deceased intended, and you can confirm it as a trusted asset and avoid probate. I know there's other states, like in Nevada, I heard that you don't even have to have an Exhibit A. It's just if it's left out, you can just do a petition to get it as a trust asset. I think that wouldn't be a bad idea if California did that, but we'll see.
And then the brokerage firms, the financial institutions and the banks, they honor that. And nope.
Mhm.
And so it makes it a lot easier to get those, even though the title of a brokerage account, for example, isn't in the name of the trust, the brokerage firm will recognize it as a trust asset and release it to the trustee to distribute to beneficiaries. Is that
I've
the way it
heard,
works?
I've heard like in Nevada, that's the case. I know California, that's not. Um, but let's say you don't have that, you just don't have any estate planning and you pass. So what's going to happen is it's going to be a long court process about who's going to be appointed as the personal representative, executor. And then sometimes there's going to be a fight about that, especially if there's multiple family members and a lot of money involved. Then you're going to have to identify the assets, and that can take some time. And then you're going to have to, collect them. And there's all these different, hearings you're going to have to go to. And then after that, you're going to have to, decide who gets what. And this could take years. Right now in Santa Clara County, I know they're very underfunded at all the CLE webinars that I go to with judges. They constantly talk about how there just is no staffing, and it kind of makes sense from state budget standpoint, because we're dealing with the deceased. There's no like actual live controversy. I feel like a lot of funding, go to the criminal courts, go to the civil, or that seems to be, you got to decide things a little more timely, whereas probate, it's like nothing's really going to change. People are just dead, so it makes sense from that perspective. But yeah, just it takes a really long time, and it's just it's a hassle. And the fact that there's statutory fees involved too for compensation, the court compensation to the executor, attorney,
Right.
you can be wasting a lot of money on that when
Yeah. I think I did the math one time, and for based on the California statute and just the attorney's fee alone for on $1 million estate, I remember it worked out to around $22,000 or $24,000, kind of just right off the top, just
Mhm,
based solely on what the statute provides. Then you have the executor's fee on top of that,
mhm.
and then there's other court fees as well. So always, sometimes people ask me, and they'll come to me after a parent died, and they're like, yeah, mom had a bank account. And so, Paul, what do I need to do just so that, me and my three siblings can close that out and divide that up? And I'm like, well, we got to go through a probate. They're like, what? They're like, why in the world do we have to go through all this court mess? Because my mother had a bank account that in her will, she said she wanted it to go to the four kids. So I never really have a good answer other than, hey, look, that's just the way it is. This probate
I
system
mean,
was created probably hundreds of years ago, and it just really hasn't been improved. Certainly, technological advances have been made, but they generally haven't entered the probate field to make the probate process easier. Yeah, there's a little bit of electronic filing and things, but it's still a really kind of old and antiquated process, and it's just we're stuck with it. So
yeah,
let
will
me,
is better than nothing,
yeah,
but you're still going to have to go through probate.
yeah.
There's why in California, revocable trust, we avoid that altogether. And when you administer it, you do a lot of the same things that a probate court would do. It's just much faster and
Yeah.
private.
Want to move over to Larry. Keep them coming, man. Larry's, and I've got some comments on this. Again, not specific advice, no attorney-client relationship, but just talking generally here. Larry says, what's the best way to handle credit cards only in the name of the spouse in California? Call the company and advise of death, et cetera, and just pay off the balance when funds are available. So whether it's a spouse or whether it's a parent or some other loved one, obviously I've been involved in a bunch of these, but I'll start with, yes, a person's estate is responsible to pay the debts of the estate. So if a person dies with $1 million and they have $50,000 of credit card bills, the law is clear. You use the estate assets to pay the credit card bills. Some of the practical kind of stuff, though, is so the answer is yes, the estate's responsible for the debts of the estate. I do find that, in our crazy financial world that we have, a lot of these credit card companies slash financial institutions, they're often kind of willing to work with the survivors of the deceased credit card account owner. And so it's worth contacting them. Hey, yes, my spouse passed away, my parent passed away. I want to get this credit card off the books. Sometimes, they're willing to say, well, I'll tell you what, send us 50 cents on the dollar, send us 75 cents on the dollar, send us 25 cents on the dollar. If they're willing to do that, and you can get all that in writing, sometimes they're willing to do that. But again, know that the estate is responsible for the debt, and oftentimes the easiest thing to do is pay it. In fact, the credit card company will sometimes, if they feel like it's a large enough debt, they certainly have the right to file what I call a claim in the estate. And once a creditor of the estate files a formal claim in the estate by sending a notice to the executor or filing something with the court, then really assets can't be transferred to the heirs until that claim has been satisfied. So I could probably sit here and talk for an hour about handling someone's credit card debt when they pass away, but that's my quick 2 cents. Anything you want to add to that, Chris?
Yeah, that's great explanation. On all of our docs, we always say, provided the beneficiary survives the decedent by 120 days. There's always we like to do about 3 or 4 months, because creditors got to get their share, secured, unsecured. They're going to get a bite out of that, and that's one of the first questions we always ask too in a trust admin, and in probate too. That's one of the things that always, one of the first thing that comes up is creditors. And yeah, you haven't really worked it out like that where you get 50 cents on the dollar. That sounds like a good deal, but yeah, they're going to get it, and just might as well just follow the process that Paul
Yeah.
talked about.
I often find they're willing to negotiate more, particularly in circumstances where the estate had few or no assets. They had a bank account with $1,000 in it, but they had $20,000 of credit card debt. So oftentimes we'll prepare that inventory of assets, send that to the credit card company, and they're like, okay, I get it. There's not enough money in here to satisfy this debt. So sometimes we see that. Want to jump over to something I haven't discussed really on a video or a live stream yet, but Chris is young and he's a technology guru, I'm sure, because he's young. So I want to dabble into the AI discussion as it relates to estate planning. I'll tell you my experience, and then Chris, feel free to chime in. So just for fun, one time I got on, I don't even remember what website it was. It may have been ChatGPT or something like that. And I'm no AI expert at all. But I said, hey, ChatGPT, why don't you prepare a will for Paul Rabelais? He's got a wife named Amy. He's got 5 kids. And I put in a few particulars in there just to kind of test AI out. And so I put my stuff in there. I clicked send or whatever the button said. Lo and behold, about 15 seconds later, a document was produced by ChatGPT. And it was about what I thought it would look like. With the warning at the end, hey, review this and make sure it complies with state law requirements. But yeah, at least AI took a stab at it. It was not a valid will. It didn't have the appropriate, what we call attestation clause at the end. It didn't have all of the appropriate notary and witness requirements that we have in our state. But it was an attempt, and it was about maybe 60% of the way there. I'm guessing it's going to get a lot. I'm sure it's going to get a lot better, probably already better since I did this 3 months ago. But I know AI is entering a lot of fields. I kind of feel like there's always going to need to be lawyers, especially the good lawyers. And estate planning is such a complex field with so many different moving parts, from taxes to probate to real estate to financial assets, that you have to get that guidance. And every family is unique with customizable needs, from blended families to having children who can't handle money and wanting to make sure things are divorce proof when they go to your children. But love to hear kind of a young estate planning lawyer's thoughts on your experience with AI, and what are your best guesses as to how that kind of affects the estate planning field in the future?
So yeah, we're located in Silicon Valley, so we got a lot of tech people here, a lot of engineers, and you know, crypto has come up quite a bit recently, but even more so AI. People, they have their own. They ask ChatGPT to make their trust or will, and they bring it in. They're like, hey, can you take a look at this? And it's good if you ask broad questions where you say, like, explain this to me as if I was like a 10-year-old. It does a good job. It gets the basic stuff, but the more specific you get, not only are you putting your private info on there, you don't know where that's going. That could, bad actors could get access to that, and all very, sensitive info, the more specific you get. But yeah, like Paul said, I mean, every family's different, and there's no one size that fits all, really. At least the estate planning that I do. And it's getting better. It's definitely not there yet, but the way that the large language models work, they're going to be constantly improving. But I've seen it more, operationally for firms, not client-facing stuff, but yeah, it could definitely make things more efficient, like your operations. But I don't think, yeah, there's still going to be
Yeah.
lawyers that are needed. And there's actually, I think I read, there's 10 million baby boomers in California. And there's only about, I think I read like 6,000 trust and estates attorneys. And sure, the 10 million, all that, a lot of them maybe not don't have a lot of money, but there's gonna be a big demand coming up in the next 20 years. I think I read it was like 15 trillion going to be transferred in the next 20 years just in California alone.
Yeah.
So
Wow.
AI could help with that, but on the back end, but in terms of do it yourselfers, there's just so much that you don't know what you don't know. And there's always that disclaimer at the end, at least when I've done like ChatGPT, it's like, make sure you talk to an attorney to go over this, or a licensed professional. Like, don't take what we say as gospel, basically. But it does, it's better than
Yeah.
nothing. But it's you still, like you were saying about the attestation clauses, you need the original will, the original trust. You need that wet signature. And if you just do it on a screen and then you don't follow any of the other procedures, because it, like a trust and a will, those are, you need an instrument such as that to keep things fair with the family, especially when there's a lot of money. And if you just, that the whole point of estate plan is not something that should be done in like 10 minutes. Something you got to put a lot of thought into. And then, yeah, talk to a professional to make sure you get a more focused application of what's really relevant to your situation, not just a bunch of word salad.
Yeah. And I'm gonna tell you how I use AI or Chat GPT. I'm a rookie when it comes to that, but it's going to lead us into our next conversation. So, many of I put out videos from time to time, and have these interviews with people like Chris. And so where I use Chat GPT is like, and I'll tell you what I did earlier today. I said, "Hey, Chat GPT, give me a list of any unique issues revolving around estate planning in California. So, sure enough, got a list of 8 or 10 items, and one of them was it talked about Proposition 13. So when Chris and I got on the call, I said, look, I was thinking in the back of my mind, Chat GPT said that's an estate planning issue. And so I brought it up with Chris, and Chris is like, well, that's a little outdated. We now have Proposition 19. So that kind of shows me that, Chat GPT gave me some discussion points, but they didn't really nail it. So because they can give you some outdated stuff, and when I've asked Chat GPT to give me some tax information, they'll give me the estate tax exemptions or the gift tax exclusions from maybe a year or two ago. So they got a ways to go. But that leads me to this. I've heard so much about the Proposition 13, Proposition 19. So tell, Chris, kind of fill us in on what that's all about, and what California people need to know about it, and non-California people may want to know about it as well.
That's a great example with ChatGPT too, about how, it talks about Prop 13, where, that's outdated as of the last few years. So yeah, Proposition 19, it's this was on the ballot in 2020 in California, and basically get rid of Prop 13. Well, they didn't say that in the actual, statute, but what it said was California was like, we need money to go towards COVID relief. We need money to protect against fires. So in order to do that, and this was pushed by a lot of some realtor association put like $30 million in funding to, get a lot of good press about this, a lot of PR. And it was also around the time of COVID, and a lot of fires were happening. There's a lot of public sentiment to improving that. But essentially, so Prop 13, pretty sure California was the only state where the property levels, give or take, would stay the same. You passed it to your kids upon your death. So the primary residence, you get the exclusion of any reassessment for property taxes. So, and I'm also I'm not a CPA, and I'm not, I don't work at, like the assessor's office or anything like that. But broad strokes here, about 1.025% of whatever the fair market value is, you're gonna have to pay property tax a year. So if you got here in like the 70s, like my grandparents, for example, they got here in the 70s, they bought their house for like $40,000. So the property taxes that they paid, it didn't really go up a whole lot with Prop 13. So, it's like $1,000 a year or something, when my grandpa died. And that would get passed down to, my mom or anyone wanted to live there before 2021. And they could live there, and basically you could just not pay any property tax. You can even rent it out and get, really high fair market value rates and not pay any property taxes. So it was really a good way for the rich to get richer. But Prop 19, so instead of Prop 13 and Prop 58, they actually went hand in hand. You could, primary residence fully excluded from reassessment of property taxes. And then any additional property, you get $1 million exclusion. So let's say, if you bought a house right now, around this neighborhood with the whole tech industry, there's like $3 or $4 million houses. That's not uncommon. So if you bought that, and then 1.025 or whatever it is percent, and this is all, the assessor's office is going to come up with the precise value, for their calculation. You're going to be paying like $40,000, probably more, in property taxes a year. But with Prop 19, now you can get $1 million exclusion if it was the primary residence when the decedent died, and if you're a kid, and if that kid uses it as their primary residence. Any other additional property, it's full reassessment for property taxes. So a lot of people just end up selling because the kids get it, and $1 million for like a $4 million house is nice, but that's still 30,000 or something. So the Realtor Association, they knew what they were doing. And I've heard from realtors that their revenue has gone up, twofold since it's passed. And a lot of people are really upset about it. Some people still refuse to pay the new property taxes, or they're still suing. And there's some lawsuits going into effect that are, making their way down the courts. Yeah, people are really pissed, especially the families that have been here forever. But yeah, now Prop 19 got rid of that, and now there's going to be a pretty much full reassessment of property taxes, except if you get that $1 million exclusion, which is, it's just not as generous as the Prop 13 and Prop 58, which California, I think, was pretty notorious for. Because I don't believe any other states really had it that way, for whatever reason. But now California's joined the rest of them, and you got to pay your fair share. There's no more of that, double dipping per se, where you could rent it out, or you could, basically rent it out for a fair market value and then barely pay any property taxes. Now they're saying, you got to, if you're inheriting the property, then if you can't pay it, then just sell it and get your money and go somewhere else. But yeah, property taxes are no joke here. We also, in California is the tax state. We got the state capital gains, we got the state income taxes. So this is just another thing to add on to that. And
Yeah. And I would think planning ahead regarding the house and the capital gains tax rules, how those will apply at death, can have a big impact. So I know Louisiana, California is a community property state, just like Louisiana. And when in community property states, when the first spouse dies, all the community property gets a step up in basis, which is a tremendous advantage for community property states. So, like you say, grandparent bought a house for $40,000 and now it's worth $3 million. There's 2.9 something $1 million of capital gain. But if a married couple bought that house, and then when the first spouse dies and the house is worth $3 million, that's the new basis. And so I could see where sometimes surviving spouses may get an itch to sell the home after the first spouse dies, because basically they can sell it and pay no tax unless there was appreciation after the death of the first spouse. But then if the surviving spouse holds on to it and waits, then you got to see, okay, how did the first spouse leave their half of the property? Did they leave it in a way so that the entire property would get a step up in basis again when the surviving spouse died? Or did they leave it in a way that only the surviving spouse's half would get a step up in basis when the surviving spouse dies? So and a lot of people aren't familiar with these capital gains tax step up in basis rules, because you have different rules for community property states than you do with non-community property states. So I think, with all the appreciating properties out there, and it's not happening just in California. I know in North Carolina and Tennessee and other states where, particularly where people are kind of moving to, you're seeing those property values go up and up. So that's going to be a big deal in the future. Got one, a couple more from Larry. Whenever Larry asks, Larry gets an answer. I'll be using benefit, and again, you're Larry asking some specific questions, which is great, and we can kind of give you a general answer, but to give you a true kind of attorney-client answer, we probably want to ask you a lot more questions. Nonetheless, you asked. I'll be using beneficiary designations for investment and savings accounts, life insurance, virtually everything. So again, as lawyers, we want to know, what does virtually everything mean? But house goes into a revocable living trust until the kids decide if one will buy out the other or simply sell. Should be easy and avoid probate. Did I miss anything obvious? So I say nothing you said is incorrect. If I was going to kind of say with any degree of certainty, Chris or I would want to talk to you a lot more. But generally speaking, a lot of people do. Just like we said earlier, more people are owning assets these days where they are permitted to put beneficiaries on those assets so they can pass outside of probate. Some people, their only trust asset is their real estate or their land because they were able to take care of their IRA or Roth or traditional or life insurance through beneficiary designation. So I think you're on the right track, Larry, but of course, we'd want to know a little more before we give you anything definitive. Let's see.
Beneficiary designations are great for pensions, life insurance. There's some very unfavorable tax consequences, especially, the Secure Acts, they completely changed the whole game with, IRAs and RMDs. Brokerage accounts, hair went up on the back of my neck a little bit just because they don't really provide any contingencies. At least with the trust, there's a bunch of what ifs that's covered. Very
Yeah,
easily, when you do beneficiary designations for brokerage accounts, cash accounts, stuff goes wrong, and you might not even realize it. You
yeah.
may think you're covered, but that's
Yeah,
one
it
thing
used
I
to be
push
a
back on a little
real,
bit.
it used to be a real disaster, happened all the time. Couples would have assets. They, on all the assets, they'd name their spouse as their primary beneficiary just because they thought that made sense. And in many cases, it did make sense. But in the old days, maybe more than about a dozen years ago, pre-portability, it was a big mistake to just lump everything into the estate of the surviving spouse because the first spouse to die, because everything got lumped into the estate of the surviving spouse, the first spouse to die really overused this federal estate tax marital deduction. First spouse to die never got to use any of their estate tax exemption. But now with portability, and I've made some videos about that, it does help eliminate the potential mistake that might happen when the first spouse to die lumps everything into the estate of the surviving spouse. However, that portability is not automatic, and an estate tax return has to be filed, an election has to be made in order for the surviving spouse to take advantage of the first spouse to die's unused exemption. So there's some potential TOD, POD problem, beneficiary designation problems there. So again, those are just things that, people like Chris and I spot as we go through those things with and have conversations with people.
Yeah,
All right.
portability is a great tool.
It is a
So,
phenomenal. Yeah.
yeah, now people should really try to take advantage of that. You only have a certain amount of time, do that. But yeah, that's great. It's a great instrument that
Yeah.
on the seven
I
day.
used to talk to lawyers all the time that didn't really understand the estate tax, and they'd be writing these what's commonly referred to as I love you wills, which is I leave everything to my spouse. And I was like, what are you doing? You're costing this family hundreds of thousands or millions of dollars. And then portability got enacted, and I felt like that helped a lot of people and really let a lot of lawyers off the hook for some mistakes that they unknowingly made. So yeah, portability, it's just there's no downside at all. It was just kind of this gift that Congress enacted. Essentially, I think what Congress wants to do is enable married couples to allow those families, those couples to shield 2 times the estate tax exemption from the estate tax. So portability really contributes to that. So all right. Any kind of final thoughts on your mind, Chris, in the area of kind of California and things that California residents need to know when it comes to estate planning?
Just for California, and there's new types of like little laws that are changing all the time. Like we just started getting directed trusts. It's brand new this year, which I'm still learning more about. Um, some of there's a lot of high net worth around here, so charitable remainder trusts or QPERTs, sometimes that's, although with Prop 19, QPERTs aren't as attractive anymore. So you gotta, once both parents die, you still gotta pay the reassessment property taxes. Special needs, that's a bunch of new changes with that too, in terms of
Yeah.
who qualifies. So there's always stuff like that, or like,
Yeah, I know you guys have this unique, I mean, I don't want to get too much into the whole Medicaid planning, protect
yeah,
assets from nursing home. You got your own name for it, I believe, Medi-Cal. You've got a bunch of different rules as like a 3-year look back period instead of a 5-year look back period like the rest of us have. So you got some stuff going on out there.
yeah, and all those do-it-yourselfers. Um, you're gonna get the value that it may not be evident. Sometimes you might not see the benefit of it for 30 years, but it's so much better to just ask a trusted attorney, just even if it's just an initial, I always, the first meeting with me is always free, just to kind of go over and assess. And it's my job to flesh out, kind of tease out the concerns, because, nobody says they have a substance abuse issue. Nobody, denial is this huge human emotion that, you kind of need protection from yourself, and it's important. It really, I can't emphasize that enough. And, people just say like, oh, well, they know what I wanted, or it's not that complicated. It's simple, but there's just all these things you're missing out on. And yeah, I could talk a long time about just specific to California, but I think what we talked
Yeah.
about so far is a really good stuff.
Well, I'll hold you accountable in my way, in my own little way, because I know before we started, Chris, you mentioned, hey, I've been busy, but I want to start producing some content of my own. And I think while Chris was kind of in law school, he spotted some of my videos, and so I'm gonna challenge you, Chris. I don't think there's probably enough kind of California specific content out there. I know it would be welcome, and you're welcome, Larry. Larry says, thank you, Paul and Christopher, for your time and comments. I appreciate it. So as always, thanks for joining in, Chris. Okay, Larry, Chris, thanks for joining in. I'm gonna let the rest of